What sets Malaysia apart from most other Commonwealth jurisdictions that attained independence before it is that our federal constitution contains an express supremacy clause, the one I read out earlier, i.e. Article 4, Clause 1. What then are the implications of it, considering that jurisdictions that do not have such clause, such as the US and India, have also determined their constitutions supreme? Surely Malaysia, having such a clause, must present a livelier constitutional environment. While theoretically that may be so, I would say that Malaysia's constitutional scene did not achieve full bloom until the year 2017, that is at least 60 years after independence. We must also consider that Article 4, Clause 1 remains intact and in pristine form since the very inception of the Federation of Malaya and later Malaysia. You would therefore be correct to think that the full realization of Article 4, Clause 1 only 60 years after its inception might have been too long, and you might be correct. The transcendent shift in 2017 that I am referring to is the unanimous decision of the Federal Court in a case called Semenanjaya. In Malaysia, like most other jurisdictions, we have an Act of Parliament called the Land Acquisition Act 1960, which allows the government to forcibly acquire land, subject to them making adequate compensation to the person from whom the land was forcibly acquired. Naturally, in many cases, the aggrieved party challenged the adequacy of the compensation. The issue in Semenanjaya was that a provision of the Land Acquisition Act 1960 stipulated that any High Court judge who shall determine the adequacy of compensation for acquisition shall be assisted by two lay and essentially non-judicial assessors, and that the determination of those assessors shall bind the High Court. Those challenging the provisions argued that the High Court was, by that provision, effectively rendered into a rubber stamp in violation of the doctrine of separation of powers. After a lengthy analysis of the applicable constitutional provisions, the Federal Court held that the impugned provision of the Land Acquisition Act 1960 was unconstitutional and struck it down. Under the terms of the Federal Constitution, as is accepted anywhere else in the Commonwealth, the judiciary is an entirely independent organ of government tasked with making judicial determinations. Any person can therefore appreciate the clear and obvious outcome in Semenanjaya in that by confining the High Court to external adjudicators and removing all sorts of judicial determination, it unduly restricts judicial power and renders that provision of the Land Acquisition Act 1960 unconstitutional. As you can probably guess, the issue in Semenanjaya was therefore not simply just the legal validity of the provision of the Land Acquisition Act 1960, but something much larger. And to illustrate that, I must step away from that decision and highlight the bigger problem that plagued the courts at that time.